Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers the so-called plain field doctrine, the right to counsel, and threats to law enforcement, and is brought to us by Code Blue Cam's channel. Be sure to check out the description below and give them the credit that they deserve. This will be another double feature episode, so be sure to stick around and check out our coverage of both of today's interactions. On August 25th, 2022, an off-duty sergeant with the La Crosse Police Department was driving to work in La Crosse, Wisconsin, when a vehicle driven by 39-year-old Kevin O'Shea passed him at 60 miles per hour. The sergeant stopped behind Mr. O'Shea at a red light, and when it turned green, Mr. O'Shea failed to start moving again. The sergeant attempted to pass Mr. O'Shea in the left lane, but Mr. O'Shea blocked him, exited his vehicle, and approached the sergeant's vehicle with a concealed hand. In response, the sergeant drew his firearm, but did not aim it at Mr. O'Shea. Mr. O'Shea briefly walked back to his own vehicle, then reapproached the sergeant's vehicle once again with his hand concealed. The sergeant then pointed his firearm at Mr. O'Shea, and Mr. O'Shea flipped him off and returned to his vehicle. Mr. O'Shea then proceeded to follow the sergeant's vehicle and called 911 to report the encounter. Another officer with the La Crosse Police Department eventually located Mr. O'Shea's vehicle and initiated a traffic stop. Mr. O'Shea initially pulled over, gesturing out his window at the sergeant's vehicle, but then drove off and continued to follow the sergeant to the city parking lot, where he finally stopped and exited his vehicle with his hands raised.
Hey. Okay. Keep your hands where I can see them, okay?
He's the one that pointed a gun at me. You're
Okay.
going to let him get away?
Can you get on your knees, please? Keep your hands where I can see them, okay?
Yep. Is there anyone else in the car? No. I told the 911.
We're just going to place you in the handcuffs right now, okay?
He pointed a gun at me when I was coming around the corner. I called 911. Why am I in cuffs?
We're just making sure everything's safe. We don't know what's going on. We're trying to figure out what's going on. You want to stand up for me, please? Yeah. Okay. We're just going to go in front of the squad here.
Why am I in trouble?
We're trying to figure out what's going on.
No, not at all. I called you guys. Come in.
What is it?
Kevin.
Kevin, nice to meet you. I'm Steve.
I called you guys.
Okay, we're going to check you, make sure that you don't have anything that's going to hurt me.
Yeah, why would I?
Do you carry any pocket knives for work or anything
No.
like that? Okay.
I got a gun pointed at me. I'm under arrest.
You got a gun pointed at you? Like
Really?
who?
That's why I called the cops.
Okay.
Oh, this is how it's going to go, huh?
Until I figure out that everybody is safe, I can't get into the whole what happened.
Why do you think I was chasing him? Because my phone's still going with the 911 dispatcher. Hey.
Feels like he's got a meth pipe in his right pants pocket.
Yeah, I probably got meth.
Okay, fair enough.
Yeah, no. Yeah, it's in the fifth pocket.
Okay.
Appreciate it. Forgot about that. I'm not going to
Hang
fight
tight and I'll
I'm not
figure
going to
things
fight you
out.
guys.
This is Kevin. Kevin,
Hey,
this is Nate. He's a good
I'm
guy.
not going to fight you guys. I got a gun pointed at me. Yep. What did I do wrong by getting a gun pointed at me?
We're just trying to figure it out, but you wouldn't stop for us right away.
Because I was chasing him.
Right, but you can't be chasing people no matter what.
But he's going to get away pointing a gun at me? I have no gun.
We're out with him. We know who he is.
Is it?
There's other officers over there with him.
Okay, but is it your deputy or something? You can't point something at somebody like that after they try to ram your vehicle for not going fast enough. You guys don't have permission, so don't even think about it. Do the right thing, and this is what I get, huh?
We're just trying to figure out the situation right now, Kevin.
Okay. Want me to take a breather?
Yeah, take a deep breath. Everything's fine, okay? This is a minor thing, okay?
All right, so I'm trying to gather both sides of the story. You're obviously in handcuffs. You're not free to leave at this point. What I still want to do, though, is gather your information, your side of things.
Why am I not free to leave at this point?
Because you got a meth pipe on you, and they did a high-risk traffic stop based on some information that they had from the initial
But I was
call.
the one on hold with 911, so that meth pipe is void right now. Because it shouldn't have been found because I was the one that called.
Mr. O'Shea claims that the discovery of his pipe is quote-unquote void, arguing that the officers should not have frisked him and found it since he was the one who called 911. Although evidence can be suppressed in criminal prosecutions when it is obtained illegally, it is likely that a court would determine that the officers did not violate the Fourth Amendment in discovering Mr. O'Shea's pipe. Because Mr. O'Shea fled the initial traffic stop, it is likely that a court would conclude the officers had probable cause to arrest him for a violation of Section 346.04 of the Wisconsin statutes, which, among other things, prohibits drivers from increasing the speed of their vehicle after having received a visual or audible signal from a police vehicle in an attempt to elude or flee the officer. It is unclear whether the officers intended to conduct an arrest of Mr. O'Shea at this point, but as the Supreme Court held in the 1973 case of U.S. v. Robinson, officers may may conduct a quote-unquote full search of an individual who is subject to a custodial arrest based on probable cause. However, even if a court were to determine that the officers only had reasonable suspicion to detain Mr. O'Shea, the Supreme Court determined in the infamous 1968 case of Terry versus Ohio that when an officer lawfully detains a citizen, they have the authority to conduct a limited so-called pat-down search or frisk of the detainee's person if there are reasonable grounds to believe that they may be armed and dangerous. Although the court clarified that, quote, the sole justification of the search is the protection of the police officer and others nearby, and it must therefore be confined in scope to an intrusion reasonably designed to discover guns, knives, clubs, or other hidden instruments for the assault of the police officer. Officers may seize other contraband discovered during a Terry frisk under the so-called plain feel doctrine. In the 1993 case of Minnesota versus Dickerson, the Supreme Court concluded that, quote, if a police officer lawfully pats down a suspect's outer clothing and feels an object whose contour or mass makes its identity immediately apparent, there has been no invasion of the suspect's privacy beyond that already authorized by the officer's search for weapons. If the object is contraband, its warrantless seizure would be justified. Well, given the fact that the officers were investigating an incident involving a gun with unclear details and Mr. O'Shea's flight from the police, it seems likely that a court would conclude that a pat-down was constitutional. And, as the officer conducting the frisk stated that it quote-unquote felt like he had a meth pipe in his pocket, which Mr. O'Shea immediately confirmed, it is probable that a court would determine that the pipe was seized in compliance with the Fourth Amendment.
With my life in danger, with somebody pointing a pistol at me, correct? Am I correct?
I don't know. I wasn't in the car.
Would your life be in danger if you were pointing a pistol at?
I would say yes.
Okay, so that's what happened to me. That's why I called 911.
Okay. Before you get into all this, I would like to read you. Okay, that's what I was getting to. Good. Put him in the car. Put him in the car.
I want you in the car, please. Just for now, we can take you in a second. Just can you please sit in the car for me? That's all I'm asking.
Are you just going first?
Okay, you can take a seat like that. Just take a seat like that.
I couldn't really smell anything.
Want to leave the door open?
You said he pointed the gun at you?
Yes. He pointed. Oh, you think I called 911?
How'd you know it was a gun?
Because he had it in his sick guy's hand. If I could show you, cock your hand back. Like you'd be a gangster, grab a pistol, seriously.
Well, who had the gun? Him or did you say?
I don't have any gun yet.
He's claiming that.
He's claiming he had a gun pointed at him, so that's what I have to figure out.
I'm just confused. Who had the freaking gun? Is it him or?
No, he's saying Manahano had the gun.
I think if this guy's following Manahano through traffic and like blocks him into traffic or something, Manahano pulls his gun. It's like, police officer, back up or get on the ground or something, and then this guy freaks out. Just pulled the gun on me, blah blah. And then this guy calls 911. I guarantee the gun we're looking for is Mandahano's gun because Mandahano felt a reasonable fear for his safety, off duty.
You guys can't search that vehicle, you know that, right? I called in an emergency response and I'm in trouble. My lawyer's going to eat your guys' up.
Okay.
Before you guys even touch that vehicle, I want my lawyer right now. You know I'm right. I want a lawyer.
All right. I'm done talking with you, Kevin.
Just so you know, I will subpoena the 911 dispatcher saying I called in. You guys arrested me for a gun being pointed at me.
Okay.
Just so you know.
Cool. Put your leg back there.
That's fine. Just so you guys know.
I kind of do smell booze on his breath, actually. It was in your pocket.
Yeah, but I'm cutting down, so I honestly forgot it was there.
Cutting down on how much you use.
Yeah, I'll take the meth pipe charge.
Okay.
I was in the wrong.
That's what we're figuring out right now.
I got a little worked up. I've been drinking too. So.
You hear that? I'll take the pipe. And yeah, I was worked up. I've been drinking too.
Oh.
He's yelling.
Hear him yelling. You just want to roll down your window? What's up, man?
What am I under arrest for?
Well, apparently you admitted to having a meth pipe on you.
That's a misdemeanor.
There was a lot of confusion about, there was mention of a gun. As a police officer arriving on scene with dozens of other police officers, none of us knew who involved had a gun. Could have been the other person, could have been you, could have been the off-duty police officer, I don't know.
Operator. So it's an off-duty police officer, huh?
I don't know.
That's what the problem is. Let's do it.
One of the possibilities was that you had a gun.
Tow the truck, let's do it. Tow the truck.
Tow
the truck!
Okay, I'm done explaining it to you.
I don't want to hear it anymore.
Okay.
I want a lawyer. Tow the truck.
You want the window down because of your claustrophobia, though?
No, you can suck my now. So
Good boy.
Hey, firm? Yes, sir. Thank you.
you know you guys are wasting your time, right? I'll tell you right where the weed is. You know that's illegal search, right? I asked my lawyer to be here when it's searched.
We got the Twisted Tea, open container. Here's the weed. He was being honest about the weed.
Hey, where's my lawyer?
Kevin,
Lawyer.
I don't know.
He's supposed to be here present when you search that vehicle.
So the reason that they're searching the vehicle
Because
is...
the dog hit on some bullshit.
Do you want to hear my explanation?
No,
I'm trying to
because it's
provide
bullshit. There's no drugs in there except some pot.
it. Okay, let's just work through one thing at a time. This is Officer DeFlore.
I asked for a lawyer, didn't I not?
You did.
Where's my lawyer?
I'm not required to provide
Where is
one at
my
this
lawyer
point.
for the search? Because I said you guys cannot search that vehicle without my lawyer present, correct?
Mr. O'Shea implies that the search of his vehicle is illegal, in part because he requested a lawyer be present for the search, and the officer informs him that he is not required to provide him with a lawyer at this time. As we have discussed before on ATA, canine sniffs on the exterior of vehicles are typically not considered so-called searches for Fourth Amendment purposes, and courts have consistently found no constitutional violations when officers walk canines around lawfully seized vehicles. Likewise, the Supreme Court recognized in the 2013 case of Florida versus Harris that a canine alert often provides probable cause to search, although a court may later determine that probable cause did not exist based on evidence of a dog's unreliability or other circumstances surrounding a particular alert that undermine the case for probable cause. As such, it is certainly possible that a court would conclude that the officers had probable cause to search inside Mr. O'Shea's vehicle based on the dog's alert. Finally, although Mr. O'Shea did request an attorney, it is almost certain that a court would conclude that the officers were not required to provide him with one or wait until an attorney arrived to search the vehicle. While both the Fifth and Sixth Amendments afford citizens the so-called right to counsel, the Sixth Amendment right to counsel attaches only at or after the initiation of adversary judicial proceedings. And although the Fifth Amendment right to counsel can apply to pre-arrest or pre-arraignment custodial interrogations, the Fifth Amendment only protects citizens from being compelled to give incriminating testimonial or communicative evidence, meaning that it generally does not apply to searches for physical evidence. Therefore, it is highly likely that a court would determine that Mr. O'Shea was not entitled to have an attorney present for the vehicle search, and that the officers did not violate any of his constitutional rights by searching his vehicle.
Because it is not my vehicle, right? Like, there was a gun pulled on me by a deputy, right? Undercover or off-duty deputy, correct? Correct? Am I right or am I right?
I've been very frustrated, and I can understand that, but I'm trying to explain
no, hold on.
the
Answer my
process.
question first.
Do you want to talk about this? Did you get out of your car over here?
Yeah. Did he
What
pull
did
a gun
you do?
on me?
Tell me what happened.
Did he pull a gun on me? No.
I'm going in circles. I'm going to let you take over.
Did you?
We're past that right now.
Did an off-duty deputy pull a gun on me?
I was not here for that. I'm here to talk to you right now.
I want your sergeant now.
Okay, well, you've been talking to a sergeant, okay? We don't ever have lawyers here when we're searching vehicles.
Why are you searching me?
Okay? The only reason that I am here right now is to run you through standardized field sobriety tests. Are you going to cooperate and perform standardized field sobriety tests? You will? Okay. All right, Kevin, you're going to cooperate if I take you out of handcuffs and everything? Okay, perfect. Okay, a couple quick questions. Do you have any problems with your eyes at all?
Yeah.
What's wrong with them?
I'm drunk.
You're drunk?
Yeah.
Okay. And good. All right, can you grab the straw off the end there?
Yeah, what is it? It's got to be the twos.
165.
Oh,
Not too high. All right. Place your hands behind your back then.
Yep.
Thank you. Under arrest, obviously.
For drinking and driving.
Yeah.
You hit my balls again, I'm going to kick you.
Any better not. You have a felony, so I suggest not doing that.
What the is another one? Can I get a copy of their badge numbers first, please?
2702. We don't have
No,
to
we got to write it down. I get the right. Do not force me.
I'm not playing games.
I want my lawyer. I'm not playing games either, bitch. No talk screen on your deputy? You guys are dumb motherfuckers.
We don't need a talk screen on him.
Why?
Because officers are justified in pointing guns at people.
He was off duty, piece of shit.
He's still a police officer.
The officer argues that the sergeant was justified in pointing his firearm at Mr. O'Shea, even though he was not on duty. As explained in the La Crosse PD's General Order 1.1, quote, under Wisconsin law, off-duty officers have the same authority granted on-duty officers, although the policy also states that, quote, officers who are off-duty should defer to on-duty officers when possible, and that, now quoting again, off-duty officers should act only after consideration of the tactical situation. Likewise, General Order 13.1 states that, quote, officers who are off-duty and witness criminal activity within the city of La Crosse shall notify the department as soon as possible and have the discretion to take appropriate police action. Consequently, the off-duty officer's act of pointing his firearm at Mr. O'Shea would be justified if it constituted so-called appropriate police action. Under the department's use of force policy, officers should not brandish or display a weapon as a threat unless its use is anticipated, and the use of deadly force, such as with a firearm, is justified as a last resort in the defense of self when an officer reasonably believes that they are in imminent danger of death or great bodily harm. Accordingly, it is probable that the off-duty sergeant would be within his authority to point his firearm at Mr. O'Shea, given the fact that he approached him aggressively with a concealed hand, which could reasonably suggest that Mr. O'Shea was potentially carrying a firearm.
What was his justification? I want copies of that camera light too. There was cameras on that light too. You guys are all take me to jail right now. Come on, let's go.
No.
Let's go.
Relax.
Give me the jail. Come on.
We're not going to jail yet.
You need to do a talk screen on your deputy that pulled a gun? You know what? This is the only time I wish I was black because he would have shot me. You guys would all be
What was I arrested for?
Right now, disorderly conduct, OWI. So operating.
So where's the OWI charge?
It's on the paperwork right here.
What did I really do wrong? Honestly, between me and you, off the books, what did I really do wrong?
The day after his arrest, Mr. O'Shea was charged with battery or threat to a law enforcement officer, possession of THC, possession of drug paraphernalia, disorderly conduct, operating while intoxicated, operating while suspended, and possession of open intoxicants in a motor vehicle. He was released on a $5,000 signature bond with a stipulation that required him to abstain from alcohol consumption. On July 28, 2023, Mr. O'Shea pled guilty to felony battery or threat to a law enforcement officer, and the charges for possession of THC and paraphernalia, as well as disorderly conduct, were dismissed as part of the plea agreement, but were still read into the record. Mr. O'Shea also pled guilty to operating while intoxicated, and the charges for possessing open intoxicants and operating while suspended were dismissed by the prosecutor. Mr. O'Shea was sentenced to 2 years probation for the felony conviction, with a requirement that he was not permitted to consume or possess any alcohol or controlled substances without a prescription from a licensed physician. For the OWI conviction, Mr. O'Shea received a $937.50 fine. His license was suspended for 6 months, and he was required to temporarily install an ignition interlock on his vehicle. Overall, the La Crosse officers get an A for maintaining calm and professional demeanors throughout the encounter, demonstrating a solid understanding of the protections provided by the Constitution and the limitations on those rights, and refusing to take the bait and respond improperly to Mr. O'Shea's insults. Although the officers' response was a bit unorganized, they should all be strongly commended for their patience when dealing with Mr. O'Shea's belligerent antics, and they took Mr. O'Shea's disrespectful comments in stride without taking anything personally or reacting emotionally. I applaud every officer involved in this encounter for their professionalism, and would encourage other law enforcement officers to learn from their example. Mr. O'Shea gets an F for driving while intoxicated, road raging against the off-duty sergeant, fleeing the initial traffic stop, making threats, and maintaining a combative and disrespectful attitude throughout the encounter. Mr. O'Shea also demonstrated a fundamental misunderstanding of his constitutional rights, alleging that the officers committed multiple violations when a court would likely conclude that their conduct was constitutional. Much of Mr. O'Shea's conduct speaks for itself, and I do not feel the need to explain why many of his actions were so egregious. Although Mr. O'Shea was clearly intoxicated and therefore not in full control of his faculties, this cannot be used to justify his conduct, particularly his choice to get behind the wheel while he was in such a condition. Let's move on to the second encounter, which also involves Mr. O'Shea. On May 10th, 2023, approximately 8 months after the first interaction featured in this episode, and while Mr. O'Shea was out on bail with a requirement not to consume alcohol, a deputy with the Chippewa County Sheriff's Office responded to a call regarding a, quote, agitated male subject who was trying to start fights at the Sand Bar and Grill in Lafayette, Wisconsin. The caller alleged that an individual, later identified as Mr. O'Shea, was behaving aggressively and attempting to, quote-unquote, throw hands with other patrons. Upon arriving at the bar, the deputy found Mr. O'Shea with a strong odor of intoxicants on his breath. The interaction that followed was captured on officer body camera.
Hello, good, how are you?
Outside.
Okay. This guy? Hey, bud, what's going on tonight?
Nothing. What's up?
Nothing? No, I got a call that you're being kind of unruly and we had a little too much to drink tonight?
No.
Okay, hold on.
Am I being unlawful?
What?
Am I being unlawful?
Well, that's what's been reported to me. Okay, hey, I'm talking. You need to stop here.
Hey, don't touch me.
Okay, stop.
Am I detained?
You're going to be if you don't...
Am I detained right now?
Yep, you're detained right now.
All right. Come on, put the cuffs on. That's what I like. Told you.
Stop. Stop.
No. I have no reason to stop. What are you arresting me for?
I'm not arresting you. You're detained.
For what lawful reason?
Right now, you're causing a disturbance.
For who?
Everyone in this bar.
Am I causing a disturbance?
440 County. I got one detained.
No.
Look at me. Answer his questions.
Let's go outside, bud.
No.
Yes. Let's go outside.
No,
We're going to talk outside.
For why?
Because you're refusing to talk to me right now, and I'm not going to create more of a scene in this bar.
Okay.
So we're going outside.
Is that a lawful order?
It is a lawful order to go outside.
Why?
Because you're detained right now while I'm investigating what's going on.
What are you investigating? Is there a crime committed?
I just told you.
Is there a crime committed?
Come on, let's go.
Is there a crime committed?
Let's go. Stop. Get moving.
Is there a crime committed?
I told you, disorderly conduct right now.
I'm going to your ass up, just so you know.
All right? Okay. Now you have a felony charge.
Yeah.
Let's go.
Yep.
Ow! You son of a... Ow! You realize I'm wearing a body camera, right?
Yeah, you
and it just caught
wall.
It just caught all that on there. What's your name?
Digging my pockets.
What's your name?
Digging my pockets at your ear.
What's your name?
I didn't do nothing wrong.
424. You want to step it up?
Yeah. Tell 420 to come here. Hey, tell 420.
Stand up.
You're violating my amendments, right?
Well, now you're under arrest for threats to law enforcement. So
how?
You just told me you're gonna fuck my shit up.
I didn't tell you I was gonna.
Yes, you did, man.
You might as well let go of me because I'm not getting up. Let go of me now.
No,
dude. Once my lawyer gets you, you're fucked. You know that, right? You're gonna lose your jacket.
424. You can slow it down.
Stand me up.
I was. Sit up. Sit up. Put your knees under you. Now stand up.
Why am I under arrest?
I told you. I was investigating a disorderly conduct.
Hey, I'm not talking
and
to you.
And then you told me.
Okay. Call Duncan. And
then you told me you're going to fuck me up.
I'm not under arrest.
Yes, you are.
For what?
I told you. Disorderly conduct and threats to law enforcement. All you would have to do, man, is come talk to me. We could have figured this out.
No. Because you had no right to arrest me. You guys... Oh, stop. What are you... That's the Fourth Amendment. Get the out of my pockets. Fourth Amendment.
Search.
Under arrest for what?
I told you. Knock it off.
Ow! My wrist! Help!
Then stop.
Stop. Help! There's baby!
Stand him up.
Get the off me.
Knock it off.
No, f you. You guys are Hey, freedom of speech. Amendment number 1. Amendment. First Amendment, right?
Huh?
First Amendment, right?
You're under arrest. Get in the car.
For what?
The deputy informs Mr. O'Shea that he is under arrest for making threats to a law enforcement officer based on his earlier statement. And Mr. O'Shea argues that his speech was protected by the First Amendment.
I'm going to your ass up, just so you know.
All right, okay. Now you have a felony charge.
Under Section 940.2032 of the Wisconsin statutes, it is a Class H felony to threaten to cause bodily harm to a law enforcement officer when the actor knows or should have known that the victim was a law enforcement officer. The threat is in response to any action taken by a law enforcement officer in an official capacity, and there is no consent by the person harmed or threatened. As the Supreme Court of Wisconsin explained in the 2001 case of State v. Perkins, only a quote-unquote true threat is constitutionally punishable under statutes criminalizing threats. The court determined that, quote, the phrase true threat is a term of art used by courts to refer to threatening language that is not protected by the First Amendment, and that, now quoting again, a true threat is a statement that a speaker would reasonably foresee that a listener would reasonably interpret as a serious expression of a purpose to inflict harm, as distinguished from hyperbole, jest, innocuous talk, expressions of political views, or other similarly protected speech. It is not necessary that the speaker have the ability to carry out the threat. In determining whether a statement is a true threat, the totality of the circumstances must be considered. While applying this standard, it is certainly possible that a court could conclude that Mr. O'Shea's statement constituted an unprotected true threat of physical harm, and it was clearly made without the deputy's consent in response to an action he took in his official capacity. As such, it is likely that a court would find that the deputy had probable cause to arrest Mr. O'Shea for making threats to law enforcement.
Tell me what I'm under arrest for.
Disorderly conduct.
No,
resisting arrest.
What's your lawful reason for putting me under arrest?
Disorderly conduct.
No, I didn't do nothing wrong. You walked in that bar and put me in cuffs. Okay. You guys are up here in a minute.
Did you get a wallet off him?
Yeah.
I don't have a name.
He can follow you to the jail.
Okay.
Just get going.
We'll give you all these cuffs within 10 seconds. You're f***ing. You know you're f***ing when you get to this jail, right? Hey, big boy. You know you're f***ing, right?
What is that?
You did a lot of unlawful shit, right? You know that, right? You got a call saying I was being unruly from a bunch of gay. That's what it was.
So what happened? Us two were sitting here and we were just talking amongst ourselves, and he would chime in our conversations and he would be very argumentative. We said, okay, well, you can mind your own business, is guess what I do. We moved to another table, and he stayed there, and then he started getting argumentative with the bartender at the next table, and he looked at me the whole time and was very aggressive, threatening. He seemed like he was on something.
I was like, sit the f*** down, like, you're not doing anything, like, I will call the cops, I will take a bottle over your head if I have to, like, don't with me. I want to go home, I want to go to bed,
Right.
I want no problems.
Honestly, it was the deputy going, hey, can I talk to you outside? And he goes like, am I being detained? And the officer says, no, but let's go talk outside. He goes like, well, am I being detained? What legal authority do you have? And
had you just talked to me, we could have just...
Wait till we get... So tell me what unlawful things I did.
Okay, again, for the 15th
What
time.
unlawful things I do?
Disorderly conduct.
You're f***ed up when we get here, just so you know.
Okay. I didn't take you down.
I was not resisting. I did not resist once, did I?
Yes, you did.
How? My hands were behind my back? There was 3 people on me. How could I resist? I had no weapons. You knew that.
No, I didn't.
How do you not know that?
Because you refused to talk to me.
You had no reason to talk to me.
Yes, I did.
Why?
I was called there for a report of an unruly patron. The bartender.
Me and her were talking. She didn't call you. You lying piece of shit.
Okay.
You don't realize who the f*** I am, do you? I walked in, you threw me in cuffs right away.
No, I tried to talk to you, and you told me you kept trying to walk away, so...
I can't walk away. You had no reason to take me.
I did.
Am I under arrest?
You are, yes.
No, I am. Why?
I've told you...
Because I walked away from you? You know you're Get these cuffs off me now. I'll drop the lawsuit.
You do what you need to do, man.
Mr. O'Shea argues that the deputy had no authority to detain him when he first arrived at the bar. The so-called disorderly conduct statute, which is codified in section 947.01 of the Wisconsin statutes, states that, quote, whoever in a public or private place engages in violent, abusive, indecent, profane, boisterous, unreasonably loud, or otherwise disorderly conduct under circumstances in which the conduct tends to cause or provoke a disturbance is guilty of a Class B misdemeanor. As such, it is highly likely that a court would find that the disruptive behavior reported by whoever called the police would be sufficient to at least give the deputy reasonable suspicion to detain Mr. O'Shea while he investigated him for potential disorderly conduct. Additionally, depending on what was meant by the report that Mr. O'Shea was attempting to quote-unquote throw hands with other bar patrons, it is also possible that a court would conclude that the deputy had reasonable suspicion to detain Mr. O'Shea for a potential violation of section 947.013 of the Wisconsin statutes, which prohibits striking, shoving, kicking, or otherwise subjecting an individual to physical contact, or attempting or threatening to do so, or an attempted battery in violation of section 940.19 of the Wisconsin statutes, which prohibits causing bodily harm to another. Accordingly, it is highly probable that a court would conclude that the deputy was well within his authority to detain Mr. O'Shea based on the conduct reported by the caller.
I want this body cam too recorded. I want this on the table.
Put in an open record. You can put in an open records request for that.
Shut the f*** up.
We got to the doorway and he did one of these numbers. So he's now he's got threats to law enforcement, disorderly, and
What's his name?
Kevin. He says he knows everybody and he's gonna have my jacket, whatever. So and now he's gonna break my car.
Kevin?
Yep.
Come with me.
Yep.
We're going to the jail here, all right?
I'm not mad at you guys.
Okay. You gonna cooperate with the jail staff here?
Oh yeah.
You will?
Sure. I'm not gonna fight you guys.
You're not gonna fight us?
No, I'm not gonna fight.
Are you gonna cooperate with the booking process?
Yeah, for sure.
Okay.
Why wouldn't I?
I don't know. You seem pretty.
That'd be stupid of me not to.
You seem pretty hot right now. I don't want you.
Oh,
I
heated.
don't want to take the cuffs off you and then you end up swinging on us.
No, I won't swing on you.
You're not going to?
No, you guys are fine.
Okay.
The funny part is, you guys can't search me. Because you don't have a search warrant.
We can pat you down.
You can pat me down, but you only get to use the back of your hands.
That's not true when you come to me.
You want to bet? How much you want to bet?
I'm not going to bet with you. Can you take your shoes off?
No, I can't. Because you got a warrant for me to take my shoes off?
You're in our custody now at the jail.
No, I'm not. Because I didn't do anything wrong.
Okay.
If one of you guys touch me,
tell you what,
I'm going to put all you guys on your jackets. Are going to be
Kevin,
done, right?
you say seated.
I'm going to put all you guys on. I'm going to sue all you guys. Give me a phone. Let me call my lawyer and have him come down here. Give me a phone. We'll do that, okay? You can't touch me until I have a lawyer because I requested one.
You can call a lawyer?
Okay, give me a phone then. I'll call one right now.
Oh, we'll have to bring it back to the cell.
No, give me a phone because I'll call one. You cannot talk to me anymore because I asked for a lawyer.
I'm not questioning you.
Keep looking at him because he's wrong. I did not do anything criminally wrong.
All right, Kevin, what I need you to do is I need you to stand up.
No, I'm not standing up. I'm not. What did I do wrong?
I'm not telling you that you did anything wrong right now. What I need you to do is I need you to stand up. We're going to bring you back to the cell.
Nope.
Yep. You are in our custody.
I'm in no way a threat to anybody, so please do not touch me. Or you guys are outnumbering me. I feel scared for my life.
Then stand up on your own
I
goodwill.
feel scared for my life. You guys are not threatening my life. We can do this all day, dude.
All right.
Touch me again. I dare you.
This isn't the time and place to argue.
Yeah,
what's
it's
going
really
on.
not. So let my lawyer.
The courtroom is the timing and place for that.
Call my lawyer.
Well, let's get back to the
You
cell.
are nothing but a little
back there.
You are nothing but a little peon.
Okay.
Move me if you want, but I'm not doing nothing wrong.
Okay.
Cool.
I'm not doing nothing wrong. Here we go. Lawsuit.
Stop resisting.
I'm not resisting.
Yes, you are.
My life is for fear. There we go.
He's a kicker.
Stop. Take the gun. For what? For what? For what? What did I do?
Don't. It's a criminal damage charge. Stop. You're going to get an extra charge.
You charged for what?
Criminal damage to town.
For what? Because for keeping this camera? If I use up one more time, I'm going to kill you. Get these cuffs off me now.
No.
There's many help. We're going to take the cuffs.
The second they're off, you're getting a beat the
Taser, taser,
taser! Don't taser! Then don't move!
Officers later discovered Mr. O'Shea in his cell, seemingly unconscious, with his shirt around his neck. When the officers attempted to remove the shirt, however, Mr. O'Shea started swinging at them. So a taser was deployed and he was placed in handcuffs. Mr. O'Shea kneed an officer in the head, and he was secured in the emergency restraint chair. EMS was called to evaluate Mr. O'Shea, and when they arrived, Mr. O'Shea proceeded to shout obscenities at them. Mr. O'Shea was charged with 6 felony counts of battery or threat to a law enforcement officer, 2 felony counts of attempted battery or threat to a law enforcement officer, and 2 counts of felony bail jumping for his failure to comply with the terms of his bond. He was originally held on a $5,000 cash bond, but was later released on a $10,000 signature bond. However, he was taken into custody again on August 24, 2023, and remained incarcerated from that time. On November 22, 2023, Mr. O'Shea pled guilty to 3 counts battery or threat to a law enforcement officer, with the remaining charges being dismissed but read in. And on April 29, 2024, Mr. O'Shea was sentenced to 3 years in prison, receiving credit for the 348 days he had already served. Overall, the Chippewa officers get an A+ for maintaining professional and respectful demeanors throughout the interaction, demonstrating a tremendous amount of unearned kindness and patience when dealing with Mr. O'Shea, and only employing physical force as a measured necessity when it became clear that Mr. O'Shea was not going to comply with processing. As with the La Crosse officers, the Chippewa officers were able to distance themselves from Mr. O'Shea's insults, threats, and non-compliance, and did not respond emotionally or take his conduct personally. The force used against Mr. O'Shea was minimal and necessary, and in no way seemed to be a form of retaliation for his conduct. I strongly commend all of the Chippewa officers involved in Mr. O'Shea's arrest, and would suggest that other law enforcement officers emulate their behavior when dealing with similar situations. Mr. O'Shea, once again, gets an F for publicly behaving in an erratic and belligerent manner, pretending that the officers were physically abusing and sexually assaulting him, making threats and using physical force against the officers, violating the terms of his bond by consuming alcohol, and continuing to demonstrate a fundamental lack of knowledge regarding his constitutional rights. It is clear from both of the encounters we covered today that Mr. O'Shea has a serious substance abuse problem, and although I empathize with the difficulties that such issues can create, it is no excuse for his reprehensible behavior. That being said, I do hope that Mr. O'Shea receives the treatment he needs while he is incarcerated and is able to avoid future legal troubles once he is released. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.